Thank you, Bridget. And thank you to the Innovation Factory and the Ontario Ministry of Economic Development, Job Creation and Trade for organizing this webinar for employers and employees. We're very honored to be here, and hopefully we can address major concerns for both employers and employees with regards to all these unprecedented times of COVID-19. We have a lot of material to cover, but we're going to try to make it more understandable by having divided the presentation in three sections. We're going to be talking initially about all the wage relief programs that most of you may probably be familiar with. Then we're going to pass on to discussing a bit about the regulations in response of COVID-19. And finally, we're going to talk a little bit about the law. And as this can potentially become very technical, Fatma and I have tried to present it. We're going to be trying to present it in a way that it's is plain and easy to understand for all the attendees. At the end of the day and at the end of the presentation anyways, there's going to be a Q&A session where anybody can ask any questions with regards to the presentation or any other questions you may have related to employment or legal overall, as long as we can provide any assistance. So the very first topic that I'm going to speak very briefly about the wage relief programs that have been offered by either the government, the federal government, or some of the crown corporations like BDC, Business Development Canada. The most probably popular one is the Canada Emergency Wage Subsidy, which basically what it is the federal government subsidizing up to 75% of payroll to employers to be able to maintain operational and to be able to maintain the workforce that prior to this program, some employers had decided to lay off because it was not really possible to keep certain amount of employees in operation given the decrease in income and revenue. So what the government decided to do was to provide this incentive to employers so they can actually keep employees or call back any employees that had been laid off in the past because of COVID-19 and assist the employer with 75%. This program is started in mid-March. It was going to be initially only for 3 months up to beginning mid-June, but given the circumstances, it actually got extended for several more periods, 4-week periods until the end of the year. There's going to be a total of 9 periods. Right now, we are at period number 6 that started on August 2nd and is going to run until August 29th. So every period, the employer should go and apply on a month-to-month basis to see if they qualify for the subsidy on that particular period. The criteria is that the employers need to prove that the revenue has decreased up to 30% or more, but at least 30% when compared to the same period last year. And the initial month for this year to start comparing reciprocity with 2019 period was the month of March. The month of March, though, the only requirement was for the employer to show that there was only a 15% decrease. So when you compare your sales, your revenue from March 2020, and you compare it to March 2019, if you had proved that your sales decreased, your revenue decreased for 15%, you will be eligible for it. And then April and onwards, the employer would have to actually prove that the revenue decreased at 30%. So you compare your April 2020 to your April 2019, and if there was a 30% decrease, you will be eligible for it. As of period number 5, which ran from July 5th to August 1st, the criteria changed a little bit. And now to try to make this subsidy more accessible to even other employees that probably didn't experience a sales drop of 30% or not at all, they would still qualify for a subsidy if they prove that they had at least 30% sales decrease. But even employers who experience a decrease of 20 or 10%, can also qualify, but to a lower extent on the subsidy. Even those employers who did not experience any decrease, let's say 0 decrease, but when compared to the last 3 periods, the last 3 previous months, there was actually a decrease of 50% on revenue. They also qualify for some of these subsidies. The other very popular subsidy was this one only run for 3 months, was the 10% wage subsidy. This was a temporary wage subsidy that was offered to any employer who had payroll and would do remittances. You know, when the employers pay their payrolls and they have to do the remittances to CRA. If you, for example, if you have a monthly payroll of $50,000, you could actually get $5,000 credit on your remittances to CRA towards the federal tax remittances that you do on a monthly basis. So CRA offered this for 3 months, up to $1,375 per employee, up to a maximum of $25,000 per employer during those 3 months. This actually did not get extended. This one actually ended in June 15. And then there's also other programs that have been there before, but just got modified fairly given the circumstances. The work sharing program, for example, is a program that has always been there when employers have employees that agree to have a lower workload to be able to take that extra workload and share it with another employee instead of laying that employee off. Then in the past, you could do that as an employer. As long as the employee agreed, you would have a 3-party agreement between Service Canada, the employee, and the employer, and you could do that for 38 weeks. But given COVID-19 times, now you can actually do it. It got extended. You can do it for 76 months. Another change during COVID-19 for this work sharing program was that there was a cooling off period. So an employer that entered into a contract for work sharing program for a period of 38 weeks, before they could use that agreement again with the same employee, they had to take a cooling off period. Now you can actually do it right away if you need to, given the circumstances. And in terms of also other, not really subsidies, but financial assistance, the most popular ones usually through loans. We have the loan guarantee program that guarantees up to 80% of operating cash flow of a loan to businesses up to $6.25 million for small and mid-sized businesses. And this could be used toward operational expenses. Then you had the other one through the Government of Canada, federal, which is very popular. You can still apply to it if you haven't. You have until August 31st to apply, which was the $40,000 Canada Emergency Business Account. This one has to be set up exclusively online and through your financial institution. The government will lend the business up to $40,000, and you can pay it, if you pay it on or before December 31st, 2022, you are forgiven 25% of it, $10,000, and you only pay $30,000 back to the federal government, no interest. Again, a lot of people, we've had clients who are not very tech savvy because this is an online application, but we've directed them to go to their own branch in their financial institution, and usually they have advisors that can assist you in setting up this loan, and then setting it up with your financial institution, because what you'll see is kind of a loan in your bank profile. And then you have the Crown Corporation, a very popular one with BDC, Business Development Canada, which is the co-lending program, which BDC will lend the business between $1 and $12.5 million for any operational expense, including any capital financing that includes principal and interest, was very popular too. This one also has a deadline, and business are to apply before September 30th, again, with your financial institution only. I'm going to now pass it on to Fatma, who's going to be talking about the regulatory framework in response to COVID-19.
Thank you, Alexander. So as many of the employees are returning back to work, there are some compliance measures that employers need to keep in mind to ensure that safety measures are put into place in the workplace. There is a general law of compliance mandated by the regulations under Reopening Ontario. And the regulations provide that any employer or anyone that's operating a business or facility is to ensure that they are operating their business in accordance with the applicable laws, including the Occupational Health and Safety Act. It is also important that the businesses are operating in accordance and in compliance with the advice and recommendations of and instructions of public health officials. Employers also need to ensure that when employees are returning to the office, that there is enough room and opportunity for individuals to maintain a physical distance of at least 2 feet, 2 meters when they are in the office. It is also mandated that employers are to assess their workplace to ensure that they are protecting the health and safety of their employees and anyone walking into the facilities. And they are to do this in consultation, in joint consultation with the Health and Safety Committee or Health and Safety representatives. And this is important for the internal responsibility system of the workplace, which ensures that everyone is playing an active role to ensure that safety measures are successfully being put in place. It's also a requirement under the law that the employer is to provide their workers with the information and instructions and supervision that is required to make sure they are compliant. Although the most effective way to protect against COVID-19 and its transmission is to eliminate the exposure altogether through teleworking or physical distancing as much as possible. But if employers do choose to allow their employees to return to the office and have the choice of coming into the office, they should keep in mind some of the tips that have been mandated by the Government of Ontario to ensure that the workplace is safe. So this would mean that employers should ensure that all high-touch tools and surfaces are regularly cleaned and maintained. They should ensure that individuals are able to maintain the 2-meter physical distancing requirements. Individuals are to be limited when entering elevators or hallways. And some of the ways that the physical distancing can be implemented are through some engineering controls, such as putting up plexiglass barriers, creating walls, staggering cubicles, among many others that can be implemented in the workplace. The employer needs to also provide workers with opportunities to keep their hands clean, and that can be done through providing hand sanitizers and providing more soap in the office environment if possible, ensuring that the employees do wear protective equipment, masks or gloves when they're not at their work, when they're not at their desks or their workstations. And anyone that's returning from abroad are to be advised to self-isolate for 14 days and to monitor their symptoms. And they are to remind employees that if they are sick, that they're not to come into the office just to protect themselves and everyone else, and to hold meetings in outdoor spaces. So this image is an example of a real-life office that would normally be able to accommodate more than 70 people in the office. But if the mandated tips and recommendations by the government are implemented, this office would not be able to accommodate that many individuals anymore. For example, the green boxes on the screen would be able to normally accommodate 10 to 15 individuals in that space, but it is recommended that only one person should be in that space, and all closed door offices should be designated for one employee or one individual during that time. There are also policies and procedures that can be implemented to ensure that the workplace is safe. This can be done through self-assessment questionnaires, again, requiring employees to wear masks, sanitation, and whatnot. And an example of the self-assessment questionnaire that can be implemented by the employer is asking questions to employees before they do come into the office, such as whether they have been tested positive for COVID-19, if they have been in close contact with anyone that has contracted COVID-19, and among others, just to ensure that you are taking those precautions. There's also, among many others, there's this is a suggested app that employers can implement in their workplace to keep track of who is coming into the office and who is leaving, to ensure that they are able to maintain and provide for the physical distancing requirements that are mandated by the government. As is expected, some employees may be hesitant to return back to work because of some concerns they may have regarding safety, but those employees should be approached on a case-by-case basis, and the specific concerns of the employee need to be addressed. If, however, the employer is not in compliance with the health recommendations, this can lead to an investigation under the Occupational Health and Safety Act. However, if safety measures have been implemented and the employee still feels in good faith that they are not able to return to the workplace because of safety concerns, then employer cannot discipline such employee and should work with the individual to understand their concerns. And this would also become an investigation with the Occupational Health and Safety Act. It's also very important for employers to keep in mind that some employees might rightfully be entitled to refuse work because of their heightened risk to contract the disease, and employers should make their utmost efforts to ensure that they are working with those individuals to either make accommodations or come up with a strategy that would help the employee perform their duties. Another consideration for many employees is public transit. Some employees may have concerns.
Fama, you unmuted your speaker.
Am I good now?
Yeah.
Okay, perfect. So another concern that employees may have is riding public transit to commute to work. It is important to note that this is not a legitimate concern. This is not a legitimate excuse for employees to refuse to come into the office, but employers should work with the employee to make accommodations or come up with a strategy that will ensure that the employee does feel safe riding public transit, and some risk mitigation strategies can also be implemented. The employer can also ensure that they are scheduling their employees so that not all of them are coming into the office during rush hour and not all of them are leaving the office at that time, just to avoid the congestion on public transit. Now I will turn it over to Alexander to discuss some of the legal frameworks, such as the Ontario Human Rights Code.
Thank you, Fama. So the first legislation that we're going to go through very quickly and briefly is the Ontario Human Rights Code. This one is as employers pretty much turn their minds into going back to the workplace. They're going to be faced with questions that they need to consider as to what workforce accommodations and other related requests from employees they're going to have to address. The human rights obligations still remain for purposes to avoid any source of discrimination against employees, and so all employees employers have to ensure that all employees are treated fairly without any type of discrimination when it comes down to any COVID-19 related circumstances. Employers, keep in mind that employers always have a duty to accommodate employees, even more so during COVID-19 times, unless obviously these attempts of accommodation to employers amount to any undue hardship to the business. And we're going to see later what the definition of undue hardship is, but you have to keep in mind as an employer that you try to do your best efforts in a good faith to accommodate employees as much as possible. Failing to do so can have an employee feeling that he's being discriminated against because his or her specific needs are not being compromised. Now, what are the grounds in which an employee can feel discriminated against? It could be discrimination because of race, sexual orientation, gender, family status, or disability. Now, one of the most important ones, which is family status, employers have to make sure that they provide accommodation to employees, not only for their own personal care, but also for their family, for their relatives. And relatives that not only include children and a spouse, it can also include a spouse's relatives, and even family friends that are actually legitimately considered relatives of the family group. So it is important that an employer tries as much as possible to offer that accommodation for an employee if there is a need for personal care for family members. Not, as I said, the purpose of the Human Rights Code is to ensure that employees are not discriminated against because of that family status or because of a disability. And a disability, it's something that can be visible, can be invisible, can be something that an individual was born with or just acquired because of an accident or just acquired all over the time. And this is important why employers have to, in an effort to accommodate employees, it is important that employers do not use a one-size-fits-all approach, but go on a case-by-case basis based on any individual accommodation needs that employees have. And this is why it's important that employees share their concerns if they have one or any when required to go to work. Because if an employee doesn't express concerns, the employer won't be able to, in good faith, act to accommodate that employee. So that's when you have to really compromise that very fine line of privacy versus needs basis. And if the employer didn't provide an accommodation because the employee chose not to share certain information because of the concern, the employer won't be found guilty of discrimination because the employer wasn't aware of specific needs for some employees. Now, again, there's never going to be a perfect accommodation. There has to be a compromise from both employer and employee. And then that compromise is what's going to try to get to that degree of perfection that, although never is going to be achieved, is going to try to address both parties' needs. Employee being satisfied, felt not being left out, and employer having the employee satisfied and obviously feeling appreciated. Again, however, all these accommodations have to be to a degree of not causing undue hardship to the business. So when an employer in its efforts to provide accommodations to an employee is incurring substantial financial prejudice, that might be a reasonable argument for the employer to justify not to be able to accommodate the employee. What are the three factors that, when an employee complaining about the employer for discrimination purposes, what are the three factors that the employer can use as reasonable arguments for not having offered accommodation? Well, you have financial hardship. Then did the employee try to look for external sources of funding? So there are these government programs that actually assist employers like you that have employees with these disabilities. Did you try to look for that to try to mitigate the financial effect that is causing you the prejudice? If the employer proves that they try to look for those external sources of funding and yet still got the financial prejudice, that may be another reasonable excuse for the employer to prove that in good faith, he can no longer accommodate the employee to that extent. And then the final one, when the employer can prove that accommodating an employee is going to have health and safety requirements to other employees in the workplace, the employer may be in a reasonable position to justify why accommodation cannot be provided. But again, I think in this case, communication is key between the employer and the employee. And sometimes you have employees who have requests to the employer on a private basis. And it's okay from the employee to ask the employer, look, I'm going to share something with you. Please do not share it with anybody else. Okay, so for now, I think the next piece of legislation that we're going to be talking about, FATMA is going to be talking about, is the ESA, the Employment Standards Act, and the changes that have been adopted to this legislation in response of COVID-19.
Thank you, Alexander. As many of you are already aware, the ESA sets out minimum standards, subject, of course, to exceptions that apply to employees and employers in Ontario. With respect to these responsibilities and obligations, an employer or an employment cannot contract out of or waive any of these responsibilities that are outlined in the Employment Standards Act. So what the Employment Standards Act covers is a wide range of standards that relate to minimum wage, parental and pregnancy leave, hours of work, family caregiver leave, severance of employment, termination, temporary layoffs, enforcement of compliance, among others. And due to the pandemic, there have been numerous changes to the Employment Standards Act to ensure that some of the burdens that are being put on employees and employers are being regarded for and are being provided for. So in this portion of the presentation, I will discuss some of the changes that have been that have occurred with the Employment Standards Act to help many of the employers and employees during the COVID-19 period. Bill 186 was enacted on March 19, 2020, which expanded the scope of Section 50.1 of the Employment Standards Act to include infectious disease as a form of emergency to which an employee can take a leave of absence for, whereas the previous version of the provision did not provide for such entitlement. This amendment is significant because it allows employees to take job-protected leaves of absence without having to worry about losing their jobs or being at risk of losing their jobs. So what the amendment states is that an employee is entitled to a leave of absence where they are not able to perform their duties of their jobs for reasons related to the designated infectious disease, such as them being under medical investigation for the disease. The employee may be acting in accordance with the Health Protection and Promotion Act. The employee may be under quarantine or self-isolation. The employee may have been directed by their employer to self-isolate or not return to work due to concerns that the employer had that the individual may be exposing others to the infectious disease. The employee may be providing care or support to an individual, and the employee may be affected directly by some of the travel restrictions that have been imposed due to COVID-19. The entitlement to leave of absence is available to employees for as long as they are not performing their duties, the duties of their job, for the reasons that I just mentioned, and also as long as the infectious disease is designated as such under the regulations for purposes of the section. While the employee is on a leave of absence, although an employer can require the employee to provide evidence, the employer cannot require an employee to provide a medical note from a doctor. The evidence needs to be reasonable in the circumstances. Another significant change to the Employment Standards Act is that the individuals that an employee can take a leave of absence to provide care or support to has been expanded significantly. Prior to the amendments, the individuals included immediate family members and dependents of the employee. However, this section has been expanded to include, for example, an aunt or an uncle, a brother-in-law, a step-brother-in-law, son-in-law, and most significantly is that the section has been expanded to include individuals that considers the employee to be a family member, which significantly expands the type of individuals that fall within that scope. And also with those where an employee is taking their leave of absence to provide care for any of those individuals, again, an employer cannot provide a medical note for the individual to justify that that individual has contracted COVID-19, and that is the reason why they're taking the leave of absence. The amendments to the Employment Standards Act also provided the Government of Ontario with the discretion to make legislation in order to implement those changes. So as a result, we got the Ontario Regulations 228, and this regulation designated COVID-19 as an infectious disease for the purposes of the section that we just went through. And the regulation also provides for the application of termination, severance, and constructive dismissal rules that normally apply under the Employment Standards Act. It is important to note that the regulations state that the entitlement to the leave of absence for the infectious disease is deemed to have started on January 25th, 2020, and will expire 6 weeks after the declared emergency has ended. What this does is also provides employers with a temporary postponement of employers' duties with respect to termination and severance, which would normally apply under the Employment Standards Act, but do not apply during the COVID-19 period. The amendment to the Employment Standards Act also provides that employers whose hours of work or wages have been temporarily reduced or eliminated are deemed to be on a leave of absence, and they are deemed to have started on March 1st, 2020. And with that, they are also exempt from the application of the sections in the Employment Standards Act about what constitutes severance and what constitutes termination. Normally, under the Employment Standards Act, the employment of an employee would be terminated if they were constructively dismissed by the employee and in response and within a reasonable time, they resigned from their position, or where they have been temporarily laid off for a period that is more than what is permitted or regarded as a temporary layoff under the Employment Standards Act. What a temporary layoff is under the ESA is a period of 13 weeks within any 20 consecutive weeks or up to 35 weeks in a period of 52 consecutive weeks. If the layoff is longer than that, then the employee's employment would be considered to be terminated. But these sections do not apply during the COVID-19 period where hours have been reduced or their wages have been eliminated. This is also the case with the severance section of the Employment Standards Act. Normally, there are grounds for which an employer's employment would be considered to be severed, but again, due to during the COVID-19 period, this section does not apply as it would normally. There are, of course, exceptions to this, and where the normal application of the sections would still apply. We will not be going into details about these exceptions, and we highly recommend that you consult a lawyer if you do need further information regarding the application of these sections. So what a constructive dismissal is where an employer makes significant changes to the terms and conditions of an employee's employment without the consent of an employee. And as mentioned, if they resign within a reasonable time following those changes, then their employment is considered to be terminated. But again, Section 7 of the regulation provides that the following grounds do not constitute constructive dismissal, such as the temporary reduction or elimination of the employee's hours, or again, with their wages. Another significant amendment is that any complaints that are filed under the Employment Standards Act that an employee would usually have a right to file under the Employment Standards Act are deemed to have not been filed if this was done so before May 29, 2020, and they are not considered to go through at that point. So what these changes, amendments mean for employees and employers in Ontario are that employer obligations with regards to providing a notice, for example, to an employee that they're about to terminate are temporarily postponed, because normally under the Employment Standards Act, an employer would have to provide the employee with the notice requirements under the Employment Standards Act, or in lieu of it, they can provide payment. But they are not required to do so during the COVID-19 period. And there's also severance pay or termination pay that would also be applicable under the Employment Standards Act, which have temporarily been postponed. Another benefit to employees and employers is that because many employees are deemed to be on a leave of absence, employers can bring back many of their workforce and be able to maintain them as they are deemed to be on a leave of absence and not considered to be terminated or severed as it would normally. And this brings a sigh of relief for many employers in Ontario. And I will turn it back to Alexander to discuss the Workplace Safety and Insurance Act.
Thank you, Fana. So the last legislation that we're going to look at is the Workplace Safety and Insurance Act, which is actually administered by the WSIB, the board, the Workplace Safety and Insurance Board. And basically the purpose of the legislation in the board is to really promote the health and safety of workers in the workplace. And when there is a worker or workers that suffer injuries in their workplace, to provide for assistance, financial or otherwise, benefits for the prompt recovery of the employee to go back to work. So COVID-19 can actually be considered a potential workplace-related injury. And when an employee comes to the WSIB with a claim of having contracted COVID-19 at the workplace, the way the WSIB, the adjudicator in the WSIB, is going to assess whether or not this is a workplace-related injury is a two-step approach. The first one, the adjudicator, the board, is going to assess, is going to ask whether the nature of the employment put the employee at risk, at exposure of having contracted COVID-19. So they're going to be asking questions of what type of work does the employee does, what type of exposure at the office or in the workplace does the employee have? Does the employee face the public all day? Is the employee exposed to potential patients with any disease such as COVID-19, dental hygienists, nurses, whatnot? Once they establish that, then they're going to go into the second stage, stage of the test, which is if this employee was exposed, has the employee in fact been confirmed by a medical professional? Has the employee been diagnosed by a medical professional that the employee in fact has COVID-19? So they're going to be looking at, okay, well, if the employee was diagnosed by a medical professional of contracting COVID-19, what was the period of incubation to determine whether or not this was an injury acquired in the workplace, or maybe was acquired at the time that the employee was on holidays. And once they assess those questions, they're going to approve or reject the claim. And even claims from employees that do not meet that criteria, they're going to still be assessed on a case-by-case basis, individual basis, to determine whether or not, at the end of the day, the employee has COVID-19 because of work-related circumstances. So now it's very important to understand that the board, the WSIB, will not, or will refuse claims, will not provide coverage for employees that have not been officially diagnosed by a medical professional with COVID-19. So employees that present the symptoms and by the employer are sent home just out of precaution, they won't be covered by the WSIB until they prove that they are in fact COVID-19 positive. Now, there have been some proposals to amend the legislation, to amend the WSIA, the Workplace Safety and Insurance Act, through a recent bill, obviously due to COVID-19, Bill 191, which proposes that any essential worker, any worker that works at an essential industry as per the list of the Emergency Management and Civil Protection Act, any worker that is positive on COVID-19 should not go through this two-step approach, should not go through that evaluation, but right away from the outset, if that person who's an essential worker is positive, COVID-19 positive, should be presumed already without any evaluation, without any assessment, should be presumed to have acquired COVID-19 as a workplace injury. Now, the bill just passed the first reading in May 2020, still in debate, so we'll see that what the outcome of that is. Finally, in terms of going back to the beginning of our presentation about subsidies for employers, well, the WSIB has also extended some financial, I guess, ease to employers to help on any burden caused by COVID-19, which is recently they've offered employers some kind of financial relief by allowing them to defer any premiums, reporting, and payments up to August 31st, 2020, without any consequences of interest or penalties to be accrued. So that's kind of, I guess, the contribution in terms of financial for employers not to, I guess, to be given a break on the remittances for the premiums on the WSIB. Now, there's nothing that the employer needs to do. This is just going to be offered automatically to all employees that actually pay WSIB premiums. And the only thing is that the cost associated with COVID-19 claims, also everybody's going to see an impact on the cost of the premiums. Whether you had 1 or 20 employees, is not going to be based on a case-by-case basis, employer-by-employer basis, but rather on a schedule-wide basis. So if you're an employer in this specific industry, type of industry, your premium is going to be this one. Whether you had cases or not, everybody's going to be paying the same premiums. And I think that pretty much covers the extensive material that we had. I try to do my best in answer some questions in writing in the Q&A icon to, I think, 1 or 2 of the attendees. At the same time, trying to obviously pay attention of the webinar. So if the answer was satisfactory, or you still need some clarification, happy to leave not the ground, but the screen to the attendees for any questions.
Okay, thank you so much for this presentation. And yes, I saw that you were answering the questions in the Q&A. Now, I saw that you answered privately to the person. So just in case anybody else had the question.
Yeah, sorry, I guess.
No, that's okay. No worries, no worries. So I'm happy to go through. So it was in regards to does the right to know overrule the employee's right to privacy in the case of COVID infection? And so Alexander's answer to that was privacy must be balanced against duty to disclose. Therefore, what employees must disclose to employers is anything that may affect employees' jobs. So in general, disclosure in employment is just a need-to-know basis. And also, as a side note, I originally had put that the deadline for Beyond Boundaries was August 31st. It's been moved to September 11th. So if there's any questions right now, I'm allowing everyone to talk, so I'm giving you access. If you have some questions, feel free to raise your hand. There's a little raise the hand feature at the bottom there to get my attention.
And sorry, Bridget, and also just to expand on the answer that I provided to one of the attendees, it is really on a need to know basis, and this goes back to when I was talking about the Human Rights Code, which is if disclosure is for purposes of accommodation of an employer to an employee. If the employee does not disclose certain personal information because there are concerns on that employee's or employee's relatives' health, the employer won't be in a position to offer the accommodation that the employee may need. So at that point, that's what I was saying, it's always a balance into privacy, accommodation, and acting in good faith. So there's not going to be perfect accommodation, but the more information is voluntarily exchanged, the better the job between the two parties can be done.
Yeah. And the question was from Heidi. So Heidi, I've given you talking permission. So do you want to just let us know if that answers your questions, or if you have any follow-up ones? Please apologize for my dog.
I think your dog has a question.
He's had nothing but questions this whole time. I'm so sorry. So Heidi, just let us know if that answers your question to your satisfaction, if you have any follow-up.
All good. Thank you for the answer.
Wonderful. Thank you. Thank you for the questions. Now, if anyone else has any questions, we've got about 4 minutes, so happy to take one or two. If not, we're happy to put you in contact with either Alexander or Fatma, or any of the RICs that I mentioned were partnered on this session. We will be, we've recorded the session, we will be posting it. You can request it privately from myself. Oh my goodness. You can request it privately from myself, and or you can find it on our resource page on our website post-session. So I would like to thank all attendees for joining. Feel free to raise your hand if you have a question. We've got 3 minutes.
Sorry, Vijay, I'm sorry I guess there was another question from the same attendee, Heidi, with regards to EI. So if you are required to isolate yourself, does EI covers. So initially it was, but then CERB to cover that role. And if you are required to isolate because of work related circumstances, then you apply for CERB. That's pretty much the replacement for EI in those circumstances.
Thank you.
Okay, excellent.
I have one more question.
Oh, yes, go ahead, go ahead.
All right, so vacation time. People are coming, people are going. The government says that if you've come in contact with somebody, and remembering that there are people who are being still repatriated. So there's Canadian citizens coming from higher risk countries, or even the US included. The government says now that it is 2 weeks isolation if you come in contact with anybody from any of these places. Can we extend that to if you are coming in contact with anybody from out of the province? Does the employer have the right to amend the rules to accommodate their staff?
Thank you for the question. So what a lot of employers are doing now, obviously depending on the circumstances, is when you go to travel, whether for vacations or for work, and when you come back, you have to isolate yourself. What they usually propose to the employee is this 2-week, 14-day period isolation, you can work from home. And depending on the circumstances, if the employer for some reason is not feeling well, or the employee feels that needs an extra week because although not diagnosed positively on COVID-19, there's some, pain or fever or any symptoms that the employee communicates to the employer might say, why don't you stay an extra week and see until, and that, as the employee is actually working, is not really on holidays at home, it's considered time in work, on work.
Right.
I don't know if that addresses the question, Heidi.
Well, we have two sets of employees. We have those that can work at home, and then we have those who cannot.
Okay.
So I guess I'm sort of targeting the ones that cannot. And my question still is, you cannot work at home, but you've decided to take a family vacation to go to British Columbia. You're flying, you're hoteling, you're doing whatevering. Is it our right as an employer to say, hey, although you have not been out of the country, which is what the rules are all about, out of the country, we want you still to go on 2 weeks isolation prior to coming back?
That would be the more prudent thing to do, especially because you don't want that person to come to work and then potentially exposing the other team, the other part of the team to it. So yeah.
Right.
That would be,
okay. So I was just wondering if it's our right to do that. We have been doing that, and I just wanted to make sure that it's not going to have some backlash further down the road, saying that I'm going COVID crazy or something. You know?
No. A lot of the things from the government, they're mandated. Other things are recommended. And what they ask is you exercise a good faith discretion, that you make sure, remember what we talked about, undue hardship? It doesn't cause undue hardship to the business, considering also you're not going to pose any risk and safety hazards to the other team, to the other members of the team.
And just to add to that, Heidi, I did discuss in my portion of the presentation with the Employment Standards Act is that any person that is asked by their employer to not return to work because they have concerns that the individual might pose a risk to other employees, that employee would be deemed to be on a leave of absence.
Right.
Based on the changes of
that's how we've been handling it, but we're getting some pushback because our rules are a little more strict than the government recommendations are. And so we're getting some pushback. And my comment is that's our rules. Take it or leave it. You want to go enjoy yourself, but we can stop you from coming back until you get your quarantine.
And then at that point, if the employee is required to stay out of work for those 2 week period, they can apply to serve, right? Which is the replacement of EI for those type of circumstances.
Right. Or do it through WorkShare, if I'm not mistaken.
As well, for example, that we talked about.
We're all on the same page. Thank you. I just wasn't sure if I was overstepping by, putting in a regulation that the government had mandated, but it was a corporation mandate. Thank you.
Thank you. Those are great questions, Heidi. And I'm sure other people were wondering as well. Okay, so we've gone about 2 minutes over. So I will take this time to thank both Alexander and Fatma again for a wonderful presentation, as well as the ministry for helping to facilitate, and my fellow RICs for funneling their clients over. So again, we will have this session recorded on our website very shortly. So thanks again for everybody for joining us. And
we'll share. We'll also provide you with a copy of the presentation in case you need to share it as well.
Okay, perfect. That's hugely appreciated.
Perfect.
Okay, awesome. Thank you so much. So with that, I will close out the session. And if you have any follow-up questions, please don't hesitate to connect with Innovation Factory.
Thank you. Thank you, everybody.
Everyone. Take care.
Bye.
Bye.